Minister. Senator Madigan.
Thank you, Chair. Thank you for your attendance. Mr Yates, what procedures and processes led to the CEFC's decision to provide $70 million in debt financing to Pacific Hydro for its Portland Wind Energy project, enabling Pacific Hydro to construct stage 4 of the project and develop a retail business for renewable energy? Would you be able to enlighten us as to who approached the CFC and requested the financial assistance on behalf of Pacific Hydro, who it was pitched by, who were involved? I'm happy to take the question on notice if necessary.
For the purposes of time, Senators, I'm happy to take the question on notice, but if you would like me to answer it, I also can, but it's a bit long-winded, if you like, for want of a better word. But the only thing that I can say is that we actually have direct relationships with all of the energy producers, so we actually know them directly, so there's no party in the middle, should you say, between us and PAC Hydro. We deal directly with the company in relation to any of their financing needs.
So if you can take that on notice, I'd appreciate that. And is it your understanding that Pacific Hydro were relying on income from renewable energy certificates created by earlier stages of the Portland project, including the Cape Bridgewater wind farm, in order to secure the finance that it eventually obtained from the CEFC?
The project loan is secured against all of the assets, including a long-term PPA from PAC Hydro. So the renewable energy certificates that may be relating to the project are one part of the overall security. They're not the only security to which the CEFC looks at. Obviously, if there were no renewable energy certificates, it would affect the income of that project, and then we would have to rely more closely on the overall PPA that Pacific Hydro itself has provided to support the project.
Thank you. Recent acoustic investigation undertaken at stage 2 of Pacific Hydro's Portland project revealed a correlation or a trend between the occurrence of specific infrasound frequency that occurred at various phases of operation at Cape Bridgewater Power Generation Facility and the residents' reports of adverse sensation and health effects. This could have ramifications under the Public Health and Wellbeing Act 2008. If so, would the facility be in breach of conditions relating to its financial arrangements and contractual obligations with the CFC?
Yeah, Senator, all projects are required to comply with the law. So currently it's dependent upon whatever planning permits or requirements were there at that site. If the project fails to meet its compliance obligations, then there normally is typically a right of termination of the funding requirements underneath facilities. I mean, we do expect people who are borrowing from any financial institution, it's common whether you're public or private, to use the money in a way which is used for lawful purposes, and if they're not used for lawful purposes, then it's unlikely the money would for very long be available. It would typically be an event of default.
Did the CFC make sure that it had appropriate evidence to satisfy that Portland Wind Energy Project's earlier wind farms had met all conditions of planning, permit and approval requirements before providing the $70 million in debt financing to Pacific Hydro for the refinancing of these stages and stage 4? Whose money is at risk here if these projects have not met their planning permit conditions?
Well, in relation to the first question, there is an extensive due diligence process that we go through to try and determine. I mean, obviously every lender does, because you don't want to lend to a project which is in default, and that relies upon detailed legal due diligence and specialist due diligence in relation to any project that we lend to. With regard to exposure to any project which is in breach of environmental obligations, then it depends upon the security arrangements underlying the loan. Obviously, the person who owns the project, who has equity, would be very exposed to a problem like that. Obviously, if they have then lost all of their money and gone broke, then the lender would then step in and own the project and would have to rectify that problem for the purposes of trying to create recovery. So you go through a tiering of risk if a project runs into problems, but primarily managing that type of problem relates to the operator of the project, and the operator of the project is Pacific Hydro at this stage.
Mr Yates, when any person or any organisation comes to the CFC to obtain funding, and they claim that they meet environmental planning regulations, does the CFC just accept sort of a tick and flick box, or do you go and check every claim in that?
We have external lawyers that work with us on transactions, so
Sorry?
we require external law opinions as well from external law counsel, who will actually go through and check and try and check to make sure that any of those items or representations that the company has made are actually legitimate. Now, obviously, you do expect companies to make valid representations, but it is not for us to take those representations without due inquiry to check the validity, whether those representations are actually true. So, we do the same due diligence we would do with any project, whether it be the commercial sector or the private sector, as we look at representations and we try and analyse those ones to avoid any possible risk. Because you're right, if those representations are wrong, the project can fail.
My final question, Chair. The other day I asked a question of the Clean Energy Regulator where I said, have they got an unambiguous statement from the Victorian Minister for Planning as to whether the facility was compliant or non-compliant? And they said they have neither.
Yep.
Okay, they have neither. So it's in fact, it's in the demilitarised zone, no man's land. It's neither compliant or non-compliant, but you lend money on a thing that they've told me is neither compliant or non-compliant. There is not a definitive statement as to compliance.
I think the question comes around to legality. The project is legally entitled to operate. I agree with you, Senator. There is a ridiculous world where people cannot get clarity in relation to this. This is a planning failure, in my view, that a minister or a government or a responsible entity needs to actually draw a line and say whether it is compliant or it is non-compliant.
And obviously that has implications for the risk profile of the project, if I might say so.
Yeah.
So wouldn't you say, Mr Yates, that then a project that has neither a definitive statement of compliance or non-compliance then exposes the CFC to greater risk? But you're still loan for it. You still lend money.
Yeah, the answer is that is a situation that's occurring right across Victoria. Unfortunately, there are numerous wind farms in Victoria where you can't get clarity.
But you're still lend money to them. Is that right?
Well, at the moment, we've been trying to actually encourage there to be some clarity in relation to this matter. We are certainly not looking too hard in Victoria at the moment because there is continued unclarity. But in relation to other states have got planning rules in a better position.
Senator Madigan,
Thank you, Chair.
Thank you. Senator Singh.